We got to find a way to get your addiction under control. If that requires me to not let you walk out of here, that's what I'm going to do.
Have to collect bottles just to get the bus fare down here. For them to tell me, well, if you don't have the money, then you can't drive anyway. It was a catch-22, so I was like, I've even put my applications in so I can at least have the money to pay for my drug screen. And there was no one to borrow from. I have no one.
Does call the case of the people versus Cedric Blair.
Assistant Public Defender on behalf of Blair, who is opposed. Mr. Blair, state your name for the record.
Cedric Blair.
Judge, we're asking for an adjournment in this matter.
You have his violation from the second.
I do, Your Honor.
Let's address that.
Okay. Your Honor, I do understand that the violation report indicates a number of missed tests as well as a number of positive tests on the Soberlink device. And I see also that there was a missed test on 129, and the test before that on the 22nd was positive. I've had an opportunity to speak with my client about this. Mr. Blair he was very upfront with me. He wants to be very upfront with the court. He has admitted that he has been struggling. He states that he has been trying to do this on his own, but it's clearly something that he cannot. I've spoken with him about all of the options available. We're going to ask, I do have on the printer, but I can submit.
Is he admitting to the violation?
He will be admitted to the violation.
Okay, go ahead. I'm sorry.
I do have a release to treatment order drafted up if the court would be willing to sign that. I've explained to him the benefits of a lot of the treatment facilities that Washtenaw County offers, or at least we're able to get him to. And he says that he wants to take a serious attempt at this. He's looking to reunite with his 18-year-old daughter, and he wants to be the best version of himself when he does that.
If I may, I'd also like to add that I have 2 different interviews coming up. And if it's somehow that I am able to walk out of here without going to treatment, I mean, treatment is definitely an option, but could we maybe, I would suggest an alcohol tether versus the Soberlink, because I have actually forgotten this in places before, which is why I missed a couple tests and whatnot. But that would be—
Well, the missed tests don't bother me as much as your positive test. And the Soberlink doesn't, or the Scram doesn't necessarily help with that. We got to find a way to get your addiction under control, and to really have you fulfill what your counsel's indicated is probably the most admirable thing you want to do, and that is be the best version of yourself for your daughter. All right. If that requires me to not let you walk out of here, that's what I'm going to do. Okay, because I think you want to do that. And I just looking at the best way to do it. You had a number of, you're really slipping. And I'm not, in saying that, I'm not saying that you weren't trying. I think that you were. You just have come to the realization you can't do it yourself.
Judge Simpson is separating 2 very different issues here: whether Blair made some effort and whether that effort was enough to protect the court's objectives. His attorney makes a strategically sound concession by admitting the violations instead of contesting documented missed and positive tests. That preserves some credibility and allows the defense to shift the conversation from punishment toward treatment. But Blair weakens that strategy when he suggests replacing the portable testing device with an alcohol tether. The judge immediately identifies the flaw. Changing the monitoring technology does not treat the underlying addiction or explain the positive result. Did you notice how Simpson acknowledges Blair's effort while still emphasizing that he is slipping? That language shows the court is not treating him as deliberately defiant, but it is also signaling that continued release may no longer be considered safe or effective. Blair's desire to reconnect with his daughter gives the defense a powerful rehabilitation argument, yet it also gives the judge a reason to impose stronger intervention. If voluntary compliance has repeatedly failed, would another monitoring device realistically change the outcome, or merely document the next violation?
I'd also like to add, if I may, another thing that for my stress is trying to find employment. And I have, like I said, I have an interview today at 1:00, and I have an interview at Biggs tomorrow. That was part of my stress and my basis for not coming to drop. I called the number, but if I didn't have the money, I didn't come. Because, I have to collect bottles just to get the bus fare down here. For them to tell me, if you don't have the money, then you can't drop anyway. So it's like, it was a catch-22. So I was like, I've even put my applications in at McDonald's so I can at least have the money to pay for my drug screens. And there was no one to borrow from or nothing. Like, I have no one.
Yeah. All right. What I'm going to do is I'll adjourn this probable cause over to March 5th, 2026 at 9. At this point, based upon the violations and that he's admitted to those violations, I'm going to cancel the bench warrant that's out there. But I'm going to revoke his bond and remand the defendant to custody. I will sign the order regarding release.
Thank you, Your Honor. I'll have that submitted to the court right away.
I apologize, Your Honor. March 5th.
March 5th.
This ruling reflects a risk management decision, not simply punishment for missed appointments. Blair admitted the violations, the report contained positive alcohol tests, and even his own lawyer acknowledged that he had been unable to manage the problem independently. Once those facts were established, Judge Simpson had a concrete basis to conclude that the existing release conditions were not working. Blair's financial explanation may account for some mistesting, especially his claim that transportation and testing costs created a catch-22, but it does not resolve the positive results. That distinction is critical. An inability to pay can support modifying how compliance is monitored, but it does not erase evidence that alcohol was consumed. The judge therefore revokes bond while signing a release to treatment order, creating a controlled path out of custody if an appropriate placement becomes available. Do you think Blair's employment interviews should have justified one more chance in the community? From the court's perspective, a possible job is valuable, but treatment stability comes first because employment cannot succeed if repeated substance-related violations continue. The defense earned Blair a rehabilitative option, but not immediate freedom.
Douglas Crockett.
Under Chelsea, Virginia, with and on behalf of Douglas Crockett, who appears via Zoom. Mr. Crockett, please state your name.
Douglas Crockett.
Thank you, sir.
We are asking to adjourn for a plea discussion, and we haven't received media discovery yet.
You have not received it?
No, Your Honor.
How soon is that going to happen?
Well, we're planning to go over today.
Probable cause conference, March 12th.
Oh, excuse me.
2026.
Excuse me. Can I ask
Yes,
a question,
sir.
please, Your Honor? As far as my bond conditions, I wanted to see if I could ask in regards to where it states that I'm not able to return to the address 2129 Medford Road in Ann Arbor, Michigan. I wanted to see if that particular portion of it could potentially be lifted. That is my home address where I live with my twin brother, and I'm currently staying with my mother in West Bloomfield, and I work in Plymouth. And with doing my weekly drug test, having to come out to Washtenaw County and having to drive back, it's been very difficult due to the distance. And I was trying to see if possible, if that portion could be lifted.
Did you ask your attorney about that?
I didn't know I could ask.
Your Honor,
Know anything about that?
I didn't, Your
Probably
Honor.
not.
I would have
He
to
shocked us all.
consider it. I think he makes some valid points, Your Honor.
He does?
I would ask the court to consider his request.
Any response from the people?
Your Honor, we haven't had a chance to talk to the victim. It appears to be.
That's going to be the problem. Problem is, sir, you should have gone through your attorney with that. I don't mind listening to you. I understand what you're saying, but usually what will happen is you let your attorney know, which you've now done out loud. They then will let the prosecutor know, which you've also done out loud. The prosecutor will then talk to the alleged victim in the case. get their feelings on it, and then hopefully we can get it resolved. If they can do that and stipulate to something before the 12th, then I don't have a problem, I don't think, signing off on it. But in terms of your request right now, I'm going to deny it. I'm not going to change anything until all of the proper people have been contacted.
I understand.
Understood?
Yes.
All right. So adjourn this out to the 12th, 9 a.m. Bond will continue. Thank you.
These two hearings demonstrate how Judge Simpson distinguishes between the substance of a request and the procedure required to decide it. In Blair's matter, the court had documented violations, positive tests, and an admission. His attorney wisely pursued treatment, but Blair's explanations addressed only part of the problem. Financial hardship could explain missed testing. It could not neutralize the positive results. Simpson therefore revoked bond while authorizing a treatment pathway, an outcome designed to combine accountability with rehabilitation rather than simply leave Blair in an arrangement that had already failed. Crockett's request was different. His transportation concerns sounded practical, and both the judge and defense counsel acknowledged that he raised valid points. But the restricted address appears connected to an alleged victim, meaning convenience alone could not justify an immediate modification. The prosecutor had not yet contacted that person, and the court was unwilling to change a protective condition without hearing from everyone whose safety or interests might be affected. Crockett's decision to raise the issue personally did not destroy his request, but it bypassed the normal process and left the prosecutor unprepared. Did you notice that the denial was not necessarily permanent? Simpson expressly left room for counsel and the prosecution to reach an agreement before the next hearing. The broader lesson is that credible arguments still require evidence, notice, and proper procedure. A reasonable request made too early may be denied, even when the judge is open to granting it later. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.